Good morning. I'm Giorgio Corno. I'm the member of the Council for Italy, and I would like to invite to this conversation Alessandro Solidoro, who's a well-known and reputed Italian chartered accountant and auditor. He acts as a professional expert in judicial and out-of-court debt restructuring for medium-sized and large companies, as well as an expert for the Companies Court in Milan. He's a professor at Bicocca University in Milan and in charge of international activities for the National Council of Accountants, and acts as well as Vice President of Accountancy Europe. And of course, he's a friend, has been a friend for many, many years now. So Alessandro, thank you on behalf of INSOL Europe for making yourself available for this interview. We would like to get your view on specific issues regarding insolvency and restructuring in Italy, taking advantage from your view, which is a very interesting view. So I would like to start in our discussion with the impact of COVID-related measures which have been approved by the Italian government as well as by other governments worldwide. And specifically, I would like to get your point of view with regard to how these measures impacted on the profession of insolvency practitioners and consultants in Italy.
Okay. First of all, good morning, everybody. Thanks for this opportunity, for this chance to exchange some visions, some views about the Italian profession in the COVID-19 pandemic period. The question is very interesting. When we talk about I'm talking about the CPA accountants auditing profession in Italy. We are really involved in supporting our clients, our client companies, trying to face this emergency and trying to use in the better way the instrument the Italian law has put in place to face the emergency. So we are involved with our clients, trying to keep the business safe and trying to adopt the new rules, a set of new rules done by the lawmakers in order to support business in terms of bridging and breaching some accounting principle, just to trying to maintain business continuity in this period when economic perspectives are so negative. So we are involved with our client and we are trying to help them to get the ads that the government has performed in order to support the economic and financial balance of enterprises. That means ads in terms of support towards access to bank credit and instruments in order to postpone the payment of some taxes and other kind of instruments that are the same in all around Europe. So it's a period of really busy in terms of ordinary and extraordinary activities and in terms of comprehension of what can be used to face the situation with regard to a view of a medium and long term, because we are fully aware that over the time the activity we are doing now may be critically reviewed by third parties if our companies are going to go in bankruptcy or so on. So it's a very delicate balance between supporting, but supporting without a medium-term view.
Okay, that's really interesting, and this leads us to the second point on which we would like to get your view. In Italy, as well as in all the states which have been significantly hit by the pandemic, a large wave of insolvency is expected. So what do you think? Do you think that the Italian professionals are ready to help their clients? Do you think that there are enough professionals and who got sufficient skills to support their clients and the courts? Or do you think that some restructuring among professionals is requested in order to face such a dramatic emergency?
Another interesting question, and we have to start about a short picture of the situation of the accounting profession in Italy. We have about 115,000 professionals enrolled in the public register held by CNDC. So it's a huge number of professionals, mainly dedicated, mainly involved in accounting, auditing, and tax consultancy. But a significant part of them is already involved in insolvency consultancy, even on the side of the debtors, supporting debtors in restructuring procedure, even in the side of the court in the role of official receiver or something like this. So we have enough number of professionals to face this new weighted wave of insolvency. In terms of competencies are enough spread in the profession. Certainly, we cannot imagine the number of the expected procedures. So now, generally speaking, a professional is appointed from a court by a court a couple of 3 times for a year. I don't know if the procedure become a huge number. How can be the limit of bearing this kind of weight? If I have to wonder something about what the profession needs for the future from this point of view, I think that we need some organizational improvement, because the profession is in Italy is made by sole professional, mainly by sole professional. They work alone. The large part of our colleagues works alone, and it's difficult to face such a complex activity like insolvency consultancy without an adequate organization. So if I have to highlight a challenge for the future of the profession in this field, I think that is an organizational challenge. We have to move to a new model of profession with larger studies, with larger offices, with larger firms. That is not easy for our traditional view of the profession, but is the right answer to the challenge of the times.
So basically, an organizational restructuring.
Yeah, exactly.
Okay. which is fine. We got skills, but we need. So we will we will learn the lesson, and maybe there will be some support from the implementation process of the EU directive on early restructuring. To that extent, I would like to get your view on the implementation and on specific issues. First of all, what is the situation in Italy? Has the directive been implemented so far?
The situation in Italy is a little bit complex because we have had over the time in the last 15 years a lot of intervention from the lawmakers towards a new scheme of insolvency and bankruptcy law. And we are waiting for the entering force of the new systematic reform of the Italian insolvency law, which was expected for 2020, and now is expected for the September 2021. But the general feeling is that we have to wait for 2022 for this implementation of the new Italian internal rules. A part of the systematic reforms entered in force on 2020, but only regarding the organizational setup of companies, but not the most important part that is concerning the early warning system and the way to convince companies to act or to react to a crisis situation without expecting too much time. That is usually the best way to go in a deep situation of bankruptcy and of difficulties, generally speaking. This part of the law is postponed, I think, again, I say again, to 2022. I think that the European directive will be adopted together with this holistic reform of the Italian rules. So I really expect that Italian government shall use the possibility to postpone the adoption of 1 year, so still the half of 2022, the July 2022.
Yes, I fully share your view and your feelings. Actually, the situation is quite unclear as for people who are listening to this interview. Currently, there is a commission which is being formed by the Ministry of Justice in Italy, aimed at implementing the directive, which is what Alessandro was saying before. But I think that for our conversation, not the early restructuring or framework is of interest, but how the directive may impact on on practitioners in procedures concerning restructuring, solvency, and discharge of debt. So, Alessandro, as you know, Article 26 of the directive deals with training and sharing of best practices, the levels of expertise and conditions for eligibility. Do you think that this provision, which of course being included in the directive and having a broad view, how do you think this will impact on the way restructuring is handled by professionals in it? Do you think there will be any changes on the existing rules?
But many of the principles of the directive are now already embedded on the Italian insolvency laws. If we think about independence of the professional involved in the process, independence is one of the pillars of the bankruptcy law about the role regarding the role of the profession in the different activities they can be called to do. On the other side, we have already a professional specific expertise or competence in bankruptcy law. So we don't need a new profession for expert, because we have a part of the profession which is already expert in this kind of activity. We don't need a new register. We will have a new register, but composed by professionals already enrolled in our CPA register in Italy, only demonstrating adequate level of expertise, having done for a couple of times the role of officer receiver or something like this in different procedures. So regarding the profession, I don't imagine a huge impact of the directive. Maybe again an issue of organization, but not an issue of number of professionals involved or of competencies required. We have an adequate setup today, but maybe we need some organizational improvement, even more if the numbers we are waiting are going to be higher than before.
Okay, thank you. This is interesting, and I definitely share your view on our regulations. And finally, I would like to have your view on a specific provision of the directive concerning costs and how cost of professional may be balanced with high levels of skills requested. So this is an issue which has been very clear, and it's a very sensible issue. So how do you think the Article 27, which deals with cost and will be enacted, and what's the feeling about cost of professionals and expertise in Italy?
But I think that is really an old issue. The old issue is to have the best in the market and to pay the less you can. No? It's not nothing new under the sky. And there is some, I think, some rational and technical issue on this topic, because when we talk about fees on insolvency consultancy, we usually talk about fees affecting the activities of the debtor, but the activities of the debtor, in fact, are destined to creditors. So we are talking about someone, we don't know exactly who is the obligor of the payment, because formally is the entrepreneur, but substantially are creditors. So we are managing money of third parties. That's the point from a legal point of view. From the other side, it's difficult to have an attractive profession for young people if we cannot assure an adequate level of remuneration compared with the level of responsibility we are involved. That is not to be denied. So it's important to have a right balance between quality of the activity, responsibilities, costs, and I think that the last thing we have to have in mind is that we are not completely aware about what is the common playing field about this issue, because I'm not sure that the level of fees in the different countries are the same. So we can differently react if we start from a quite rich situation compared to the opposite situation where the level of fees is lower. So I can understand the principle generally. I can understand the legal issue, but I would like to be more informed about which is the starting level of the discussion, because I think that in the different countries costs are significantly different one from each other.
Well, I fully agree. And in the discussion we had during physical meetings and at INSOL Europe, this is an issue which comes out from time to time. And I personally have realized that the level of cost in Germany or in England, it's much different compared to the level of cost in Italy, and the culture which surrounds this topic in Germany and in England, it's a little bit different from the one which surrounds this issue in Italy. So I think thank you so much, Alessandro, for your interesting view, and we would like to get your promise from you that as soon as the directive is implemented in Italy, we will have a chance to meet again, and you will be able to share with our members your point of view about some of the issues we discussed today. So okay. Thank you very much.
Okay, Giorgio, it will be a pleasure.
Okay, bye-bye.